Stop scrolling. Stop whatever you are doing right now because what just happened in Canada's highest court is something that every single Canadian needs to hear about. Whether you own a home, whether you're in debt, whether you're just trying to survive in this economy, this is not clickbait. This is not an exaggeration. A 9-0 unanimous emergency decision just came down from the Supreme Court of Canada, and the legal shockwaves from this ruling are already starting to ripple through every corner of this country's financial and legal system. Stay with me, because by the end of this video, you are going to understand exactly what happened, why it matters to your wallet, and what you can do right now to protect yourself. Welcome back to Credit Smart Canada, the channel where we break down complicated legal and financial news and translate it into plain language that actually makes sense for everyday Canadians. I'm glad you're here today, because today's topic is one of the most significant things I've covered on this channel since we started. If you're new here, hit that subscribe button right now because we do this every single week, cutting through the noise and giving you real, actionable information. So, let's get into it. When the Supreme Court of Canada makes a decision, that already carries enormous weight. 9 of the sharpest legal minds in this country, appointed to the highest court in the land, deliberating on the most consequential questions of Canadian law. But when those 9 justices vote unanimously, all 9, not 7, not 8, all 9, in an emergency session, that tells you something extraordinary has happened. That tells you the situation was urgent enough that the court could not wait for the normal, slow machinery of Canadian jurisprudence to grind forward. Something needed to be decided immediately, and they all agreed on it. Now here is where it gets really important for you as a Canadian consumer, a borrower, a homeowner, or someone who is just navigating debt in one of the most expensive economies in the developed world. Supreme Court decisions at this level do not stay in the courtroom. They travel. They move into lending policies, into how banks interpret their own contracts with you, into how debt collectors are legally permitted to behave, and into how provincial governments structure consumer protection going forward. A unanimous ruling at the Supreme Court level is essentially the law of the land. Full stop. No debate, no workarounds. What we are watching right now is the legal equivalent of an earthquake. And just like an earthquake, the initial event is just the beginning. The aftershocks, the second and third order consequences, are what reshape the landscape for years to come. Let me put this into perspective for you. Canada's financial system is already under enormous stress. We have household debt levels that are among the highest in the developed world. Canadians collectively owe more relative to their income than almost any other population on the planet. Interest rates, even after recent cuts, are still sitting at levels that are making millions of Canadians feel the squeeze every single month. And into that already fragile environment, this ruling just landed like a dropped grenade. Here is what a 9-0 decision signals to the legal and financial community. It signals that there is no room for argument. When courts split 5-4 or 6-3, that means there is legitimate legal debate, there are reasonable people on both sides, and future challenges are possible. When the number is 9-0, it means the matter is settled. It means every single justice looked at this situation and came to the same conclusion. That kind of clarity in law is both powerful and rare. And the reason this matters to Credit Smart Canada viewers, to you watching right now, is that unanimous decisions tend to accelerate change. Banks do not wait to see how enforcement plays out. Law firms do not sit around wondering if the ruling might get revisited. They update their practices immediately. They brief their compliance teams. They rewrite the clauses in their standard agreements. And those changes affect every loan, every credit card agreement, every mortgage, every debt collection notice that comes through your door. Now, I want to talk to you honestly for a second, the way I always try to do on this channel. Some of you watching right now are in a good financial position, and you're watching this out of curiosity or concern about the broader economy. Good. This affects you too, because your home equity, your investment portfolio, your savings, they all exist within a financial system that just got a major legal jolt. But some of you watching this are in a difficult spot. Maybe you're behind on payments, maybe a debt collector has been calling, maybe you signed a loan agreement that felt wrong to you, but you didn't know what your rights were. Maybe you've been dealing with a creditor who has been pushing the limits of what they're legally allowed to do. And to those of you in that situation, I want you to understand something. Decisions like this one exist precisely to protect people like you. The Supreme Court of Canada does not exist to make life easier for the banks. It exists to interpret and uphold the law, and sometimes the law protects consumers in ways that the financial industry would really rather it didn't. This is why financial literacy is not optional in this country anymore. It is not a nice to have. It is survival. Because the system is complicated, the rules are changing, and if you don't understand your rights, there are plenty of institutions that are counting on your ignorance. That is not me being cynical. That is just the reality of how consumer credit and debt in Canada operates. The legal shockwave that just started is going to work its way through provincial consumer protection laws, through credit bureau reporting practices, through what lenders can and cannot put in the fine print of your agreements. It is going to affect litigation strategies in debt collection cases across every province. And it is going to create both risks and opportunities for Canadian consumers, depending on whether you understand what just happened and how to respond. What does that mean practically for you right now? It means this is the moment to review your credit agreements. It means if you have an active dispute with a lender or a collection agency, you need to be speaking with someone who understands the implications of this ruling. It means that if something has felt wrong about how a creditor has been treating you, there may now be stronger legal footing than ever before to push back. And it means staying informed, continuing to educate yourself, and not sleepwalking through one of the most significant legal moments in Canadian consumer finance in recent memory. We are going to continue covering the downstream effects of this ruling right here on Credit Smart Canada as they develop, because this story is not over. This is the beginning. The lawyers are just starting to file. The banks are just starting to update their playbooks. The provinces are just starting to look at what legislative changes may be required. And we are going to be here breaking it down, explaining what it means for real Canadians in real language. If you found this video useful, please share it. Send it to someone you know who is dealing with debt stress, who is navigating a mortgage, who needs to understand their rights. That is how we grow this community, and that is how we make sure Canadians stop being the last to know when something this important happens. Subscribe to Credit Smart Canada if you haven't already. Hit that notification bell so you don't miss what comes next, and I will see you in the next one. Stay smart, stay informed, and remember, knowing your rights is the most powerful financial tool you have.